at the bottom of the cliff. It's there and it works and it's in place and it's measurable. So I don't have a problem with that being a permitted activity and a catch in place.
But it does rely, though, that on whoever's doing the digging has some knowledge of what an archaeological resource is, and being able to have the skill to identify and stop before significant damage is done. How do you get through that and address that issue?
Tara, do you have any comments about the process that your team follows and the training that they have?
So I guess for us, most of, if there's any underground works that take place, it's usually in areas that are built up. So like in towns, what was it, sorry? Yeah.
Coastal areas.
So all the, if it's a rural or any outer areas, they usually are overhead. Unless you've obviously got structures where you might have a pad mount transformer that might have some cabling that goes underground that connects to a pole. But in terms of any works that we do, we've got processes in place, whereas when we do planning works, if it's overhead or underground, we always, we have archaeologists. So we have consultants, archaeologists, Lee Johnson and Elizabeth Callaghan on Northern Archaeological Research. We engage them to review and go over any of our works that we've got coming up. They undertake site visits to it and they actually advise us on any issues. There may be things that we might have to apply for an authority. We may be able to go under an ADP, or in some areas it may be fine because it might be disturbed area. Like if we're working in a roadway, for example, the area is already disturbed. Our guys are well known and are well trained in what to do. So we run a biannual refresher with our contracting staff in both the northern and the southern depot. We've had Heritage New Zealand come in and actually do a presentation of what to look out for and what you can and can't do, and also the risks of the fines that can be imposed not only individually on a person but also as a company on a whole. And following those, so I've taken up and I do the presentations to our team every 6 months with that. It's actually shown that we've had times where our contracting guy have gone out and they've come across sites, particularly if there's shell midden or something like that. They stop work, they ring it in. We ring in our archaeologists to go out and have a look. We let Heritage New Zealand know as well. There are some cases, though, that when it comes in terms of emergency work, so we take a different approach. So where it becomes a risk to life or a danger to property or anything like that, emergency works comes into effect. So we go in, but we still try to manage and maintain the respect and take care when we're working in these areas. One recent example that we've actually had where an area is not only regionally significant, it's nationally significant. In Cyclone Tam, we had a power pole snap out Orokawa Bay. And for those that know, this is where Marion Dufresne was murdered. So where our poles are located is at the high points, and unfortunately that's on par sites. Now, because of the weather that it was and the safety that it was to people and also to life and properties, we had to go in and do the replacement works. Because of the terrain that it was, we used helicopters, so it happened a couple of days after that the pole had snapped. But our processes kicked into place. Our guys rang Heritage New Zealand, Bill Edwards, the regional manager, let him know what was happening. And then we also rang our archaeologists and they prioritised that work. So they were there to monitor the works, to assist. They took all the photos and they even wrote the report, and we've submitted it to Heritage. And then the outcome of that is, they've said, because of the planning that we've done and the processes we've got in place to try and protect these sites, it's going seamlessly. So, yeah, sorry, it's a lot to take in, but we have these processes. We're very well aware of the area that we live in, the significance that it not only has to Māori, but also the significance that it has to New Zealand as a whole. We've got areas such as where the Treaty of Waitangi was signed, all those sort of things. So we take we go to great lengths to ensure that where we can protect these sites as best as we can. and we've gone through the processes where we've had to apply for authority to modify, and these aren't given lightly by Heritage New Zealand. They are the last resort where you've got no option to go anywhere else, and where we've been granted them is Tauranga Bay, Pāro Bay, and also another one was Bailey Road out Waitangi. We couldn't move the lines. Again, unfortunately, some of them are on pars. It's the high points of it is, but part of the process is that you've got to deal with the landowner. We do iwi consultation. We have the archaeologists. It goes to Heritage New Zealand. It comes back with conditions where we usually have the archaeologists there monitoring it. We have iwi there monitoring it in case that anything comes out. And then also we let Heritage know once the works and all that are complete. So we go to great steps to try and ensure that we do protect these where we can. It's a big thing for us.
Yeah. Thank you. No, thank you very much. Well, that was quite a comprehensive answer. Collis, no, and thank you. It's really helpful to hear that. I take it you have established protocols to achieve that, and so if I were to just really quickly summarise it, was you have an expert review it before you do it. You have somebody there monitoring while it's happening, and you're giving education and training to your contractors, and you have protocols in place in case you uncover something of importance.
Yes.
So are they established protocols, and are you able to share them with us?
So this is just an internal process that we run. So with our team, it's not we can share. So I run them with our team. We've kind of implemented in the last 6 years since I've been in this role. But it is a big thing we understand now. We're doing work at the moment with Tauranga Bay, where we've got to do the same thing. And there are still some remaining poles in Orokawa that we've got to replace, and I'm going to have to go through the authority to modify process for that as well.
And I suppose getting with this is, are we able to get this evidence that you've just presented to us in writing in some way?
Yes, we'll provide that.
Yeah, that's what I'm So we can have that in writing, and the council officers can have the benefit of being able to review that and come back with a response in their writing reply. So I think that's really helpful. So thank you for
if you indulge us on providing that to you in writing.
Yes, sure.
Thank you.
Kilda, I'd like to just ask, and talking about these sites and the protocols that you go through, is there provision amongst your kaimai to be able to say, I don't want to do this based on cultural values? Is there ever been done? And the workers' cultural values accepted for that?
We haven't come across that yet, so no workers have. But if that was to come up, we're not going to force them to work in an environment that they're uncomfortable with. Usually we try to, if it is significant, particularly to Māori, because a lot of our areas up here is significant to Māori, we try and keep an open mind. So if they don't want to work in it, then we're not going to force them. There's other work that they can be given.
Yeah, well, we can do it.
Yeah.
Just a quick question and follow-up question. So by the sounds of the process, is this for established sites? Is there a difference between identifying new sites for infrastructure?
So it's for both. That process is heavily followed for new sites. This is what we're doing at the moment with some of these works. Because a lot of areas, and you can see on the mapping of the ARC site that how an archaeologist has explained it is that the stars are a great representation. They're not exactly where they are, but then the areas where there are no stars doesn't necessarily mean there's nothing there. It just may mean that it hasn't been looked at. And so we've had work where we've had to work between Moerewa and Kawakawa there. You've got the hills, you've got a main line. While when we've done work there, that's all untapped area. So even though there's a no star there, we've still got to look at it.
It's all done in collaboration for new infrastructure or pathways in collaboration with your company?
So we get the review of the archaeologists. So they have a look edit, and then they'll go out to establish, okay, what is there, can we work in this area, or is actually what can and can't do. The archaeologists that we do use, they're very well respected in the northern area, and also with Heritage New Zealand. And we have a close working relationship with Heritage New Zealand. When it comes to the part of iwi consultation, we go to Heritage New Zealand because they've got contacts for different rohe into areas. They provide those names. Sometimes as well, when you're working on some of the properties, if it's Māori whenua or if it's private landowners, they may know somebody in that local area that, oh, actually you've got to talk to them, or there's this marae down the road that you might want to have accorded with them as well.
Thank you. Thank you for letting us interrupt your presentation. I think it's been really, really helpful.
It's valid, useful conversation. And it feeds into the rest of the relief sort.
Yes. It was, it's been a constant theme today.
So the next relief sort is to try and gain consistency between rules 6 and 10 within the heritage area. So Top Energy sought a new permitted activity rule for maintenance, upgrade, repair of existing network utilities, buildings and structures, and a new permitted activity rule for new network utilities. The reporting officer has made some changes to these rules to seek some alignment, and we have got some agreement there. We support the 2 different permitted pathways for infrastructure that was recommended. However, there is some disagreement with the separation of structures. So, as you heard this morning, Council maintains that a 1 metre limit of the location of infrastructure is appropriate, and Top Energy is seeking a 3 metre separation.
Yeah. And that was Mr. Superintendent's evidence really focused on that issue of the practicalities. We've read that.
And feel free to question him if you've got any further.
I think his evidence was quite clear. Does anyone like to question Mr. Superintendent?
We found it very confusing, and David and I spent quite a lot of time looking at these rules, trying to figure this out between us, why the rules refer to all zones, and we saw that as potentially a bit of a unintended consequence that would capture everything outside of a heritage area and then all zones, but then there's the infrastructure chapter. So we've really just tagged that as what we think could be an unintended consequence, but could add to confusion and be tidied up. Some exemptions to be provided for underground infrastructure, and we've just touched on that briefly already, that concept. And we support a restricted discretionary activity status. We believe that these matters are confined, it's easily definable, and we've given you a list of matches that we think are appropriate in these circumstances. And again, it's just a summary of the recommended amendments to those rules. So turning to historic heritage, very similar changes again to Rule 6. Top Energy sought the deletion or amendment to exclude network utilities. We support the reporting officer's recommended exclusion of the maintenance, repair and upgrading of existing above ground infrastructure, subject to, again, the same exemptions that we've sought for within heritage areas. And on the next slide is a summary of the changes and amendments sought, again seeking restricted discretionary for the same reasons. And that's the overview of historic heritage and heritage areas. If you don't have any other questions of us, we can move on to sites of significance.
No, I think we're happy to move on. Thank you.
Tara, do you have anything further?
No.
So Top Energy sought additional provisions within the sites and areas of significance Māori chapter to recognise the need to locate new infrastructure within these sites and areas where there is an operational and functional need that infrastructure should be there, and that any adverse effects of the infrastructure are adequately managed, and to provide for the operation, maintenance, repair and upgrading of infrastructure that may already be existing in those areas. Now, the reporting officer considered that these matters had been addressed in the infrastructure section 42A report. But we note that these submission points were not explicitly addressed in that hearing. And we also note that the infrastructure overview clearly states that there will be additional provisions that must be considered in the district-wide matters, including sites and areas of significance to body chapter. So we believe that this should be addressed in this hearing, and we continue to seek the relief sought. And we've provided in our evidence recommended provisions, which are on the next slide. So I note that the 42A has not addressed this. So that is Top Energy's position, that is our planning recommendation to you, and we leave it with you to consider. There's no questions for Carol. Shifting to notable trees. So stepping through the provisions from objectives, policies through to rules. So there has been quite a few levels of disagreement between ourselves and the reporting planner. Again, Top Energy is seeking to enable ongoing operation, maintenance, access to their lines. So it is the same consistent theme running through all of these chapters. So we disagree with the retention of the objective 1 as it was notified, because it only provides for the identification and protection of notable trees. We consider that there's no objective that clearly links to policy 4, and it's important that a policy must come from an objective and link to it. So we've recommended an amendment to that objective 1 to achieve that link. And again, it's to enable the safe and efficient use, development, maintenance, operation, repair and upgrading of infrastructure and network utilities. So turning to policy 2, we agreed with elements of the reporting officer's recommendation with respect to policy 2, the inclusion of on notable trees within the opening sentence and the deletion of original clause B. However, we do not otherwise support the revised wording, in particular the requirement for a suitably qualified and experienced arborist to supervise the pruning and trimming of branches of notable trees. And this is a theme that you will see throughout all of our evidence for the notable trees chapter. We do not consider that it is reasonable or realistic to require this obligation as it relates to pruning and trimming of branches that improve public safety or present public or damage to property or infrastructure, or to enable the safe and efficient use and operation of infrastructure or network utilities. Now, again, you may wish to speak to the technical experts on how they manage the pruning of trees and the experience that they have within their team, but it's certainly not a free-for-all.
Yeah, it seems to me, I've got another question regarding policy 5 in the same vein. It seems that I don't think anyone's disputing that you need to do works to protect, property and people, and some emergency works and stuff. But I suppose the question is how you go about doing those really necessary things. It's never really a question about whether you should do it. And so I think council's approach is, well, we accept that these things need to be done, but we want to make sure that you have somebody there who does it properly, that it doesn't, one, really look ugly and diminish the amenity value of the tree, but B, threaten its health and survival.
I think the flip side of that is the cost to Top Energy for the thousands of trees that they deal with, and having to have a qualified arborist undertake that work. And as you get through to the provisions, what does that look like for a permitted activity? And I have concerns about the operation of that rule as it's been recommended by the reporting officer. But it might be helpful for Tara.
Well, I was going to say, what we had delivered to us in evidence today is this really, really comprehensive archaeological committee about archaeological resources, and just sort of thinking why wouldn't the same approach be applied to notable trees that are equally as significant. And if it's not an arborist, but you accept that somebody skilled should be guiding a contractor with the chainsaw, you know, even if it's just, I wouldn't use a chainsaw, I'd use this thing. Whatever, or, you know, secretarial or something. If it's not an arborist, do you accept that it should be someone at least skillful to a certain degree? So
I think it's how that's formed, though. I don't believe it's necessary to have that running through every policy in this chapter. It could be a standard or a better framed rule if that was of concern, that the person has to be suitably qualified. It is the unnecessary cost of having to have an arborist involved every time this occurs. And if that isn't included, then you're triggering a resource consent cost that Top Energy faces.
Well, you're preloading your answer with unnecessary. I think that's that's still in question, particularly when you've got a notable tree. The question is, we accept that maybe works, as I said before. I don't think anyone's disputing that those works are necessary, but it's the level of care and management that you take in order to ensure that those values, which are significant, and there will be costs if you do damage to a notable tree that didn't need to be done. So what goes and costs on those?
Both sides.
Yeah.
Yep.
So again, it's what is the level of care and skill that Top Energy thinks is appropriate. And I'm assuming it's none. And it's not saying none, but you're saying not as high as qualified arborists. Is that
Exactly.
what I'm hearing?
Yes.
So
and not with an obligation to report that to council or follow up with a resource consent.
Yeah, well, maybe. So you're in search of a permitted standard, but I suppose what we're interested in is potentially a permitted standard that still gives concrete protection to resources and not left to the whim of an unqualified person who, through best of intentions, may cause quite significant damage and cost.
Understand.
Yeah. So I'm just sort of wondering how we
find that
our
balance.
way through them. And I think Commissioner Kensington might want to add to that, I think.
Good afternoon, Ms.
Good
McGrath.
afternoon.
So you mentioned that Top Energy are dealing with thousands of trees all the time, but we've only got 178 trees on the schedule. So the risk, I mean, how often would they come across a notable tree in their day-to-day work? You know, and so is that sort of narrowing down how often they need an arborist to be involved based on current recommended rules and policies?
For notable trees, it would narrow down, yes.
Yeah.
But they deal with trees all of the time, so they do have expertise in-house. And again, Tara.
Sorry, I guess the chapter is about notable trees, so that's all we're looking at. We're not looking at any other trees. So is it kind of appropriate in that instance or not?
Still don't believe it's appropriate in that instance.
Yeah, thank you.
For us, when it comes to trees or tree removal or trimming of trees, we're bound by the Electricity Hazard from Trees Regulations 2003. So whenever any trees or anything enter into the growth limit zone or anything like that, legally, as per the regulations, we've got to issue cut trim notices and we've got to keep them back from the power lines, because then you have the risk to life, you have the risk of fire, anything to do with that. In terms of, I believe that the proposal is to have an arborist with a minimum of a level 4. So we do have some people with those qualifications internal. So if we were to go through that process, is it okay if our team do utilise that, or does it have to be checked off? How would this be managed long term or moving forward?
Yeah, well, that's why I think I asked the question, is if you don't think it should be a qualified arborist, what level of skill do you think is appropriate with regards to trimming notable trees as a permitted activity?
Yes.
I don't have an answer to you for you off the top of my head. At this point, we've asked for no reference to that, and that's what the evidence is before you. Happy to go away and talk to the team, and if there's an alternative level or something that we can provide, I can undertake to do that for you.
Yeah, sure. Like, yeah, we'd like to have that assistance.
Okay.
And I just sort of reiterate that we've committed to a significant level of oversight, archaeological earthworks and excavations with regards to archaeological resources. But it seems that there might be a gap when it comes to notable trees. But if you have a protocol or a suggestion, a permitted standard that gives some comfort to those works being undertaken by someone who knows what those risks are and can avoid them appropriately, then we'd be happy to hear that. Okay, great, thanks. I'll just say, well, oh no, let's get to policy line.
Yep, let's go to policy line.
It's a slightly different question. Yeah, you lead off.
Should we skip on? We've just noted again that we've disagreed with a few of the nuances and wording, and we've recommended an or between. So not significant changes. We prefer the word infrastructure because it is defined within the RMA. It's more consistently used elsewhere in the proposed plan. And again, minor amendments to policy 4. Policy 5.
Yeah, well, I mean, we've actually got some recommended amendments from council. So to policy 5B, the added words of efficient use, maintenance, efficient use, operation, maintenance, and repair of infrastructure, perennial relocation of the tree is not possible. That's the council recommendation. Yeah. My question, and I'll put to both parties, is that a little broad? I mean, because I was sort of thinking, you know, you could apply that reasoning to pretty much any notable tree, right? Efficient use, operation, and maintenance and repair of infrastructure. That's all infrastructure, isn't it?
Yes,
We certainly want all infrastructure to be safe. We certainly want it to be efficiently used and operated. And it's related to the repair and maintenance. I mean, I'm just wondering whether that might be a bit broad as a policy. I mean, council officers have to think about it. If you've got any comments, this would run now.
And clearly, Top Energy don't believe that it's the broader the better. It's necessary for the continued operation. So from that perspective, I believe that wording is appropriate. Possible was where we had concerns about what that meant. Possible is quite a question mark, and we considered that feasible was a more realistic, measurable term. I'll leave council to consider your concern.
And we don't need a response from council, just raising that questions. Anyway, otherwise, we understand those amendments that you've suggested. Anybody else want to jump in?
And finally, running through to the definition of emergency works and rules 2 and 8. I did manage to report the addendum 42A and heard the reporting officer this morning referencing the recommended changes to accept the emergency tree works definition. So obviously we support that change and appreciate that. However, we still maintain that there should be additional changes to Rule 2 and 8. Again, linking back into that obligation for a level 4 qualified arborist, and that work should be undertaken in accordance with the electricity hazard of trees regulations.
Yes, and I think we've signalled that we want to understand what the difference is between all these levels of arboricultural expertise, and we'll have that information provided to us later. And there are a few slides just summarising those rule changes
in a summary of the key takeaways, but I appreciate time is running on for you this afternoon. So
No, that's okay. But I actually have another question for your engineer. So, Mr. Subtitles, are you still there? Can you hear me?
Yes, I can.
I mean, I've read your evidence about the width issue, and I'm just sort of thinking it's through. So at the moment, the rule has been rewritten to allow 1 metre either side. Is that correct? 1 metre either side.
From the original location.
Yes.
The intent is, I guess, to create a circle.
Correct. And obviously, Mr. Subtitles, you've provided us with the evidence as to why it needs to be wide, because things might be. But I suppose my question is, that's 6 metres. That's what we're talking about is a 6 metre corridor permitted, and whether that, whether we might need to reconcile those two really important things, which is the practicality of being able to make it work in a real life sense, which is in your evidence, but it being quite a wide corridor in areas that you're acknowledging may have significant businesses. Just wondering.
A big thing for us is when it comes for, you've got a pole in the middle, and if we're going to have to put a new pole in, you can't go too close to the existing because it compromises as soon as you dig. So that's why it's staying 3 metres, because it may go north, it may go south, east or west, but it's close by. Also, sometimes you may have blocks or anything that's at the base of it. And so that's one of the reasons why that we want a wider.
And then just to add to that, with regards to ground-mounted assets, you might have, well, in all instances, for example, a transformer or a high-voltage switch would have a concrete plinth. That concrete plinth on its own would need to have a length of cable, for example, terminated or connected onto it. So to do that, you might have to dig besides the asset that has failed, and you need to have, that area barricaded and contained off, and you need space as well for the electrician to get into that entrenched hole and make off those terminations to install it into the new asset. Where we have a like-for-like asset, if most of the assets and infrastructure is quite old, so and all of the new designs and all of the new assets that we have now are larger in size and in footprint, and those are to meet all of the new electrical safety requirements. But where we have an existing asset that's like-for-like and can fit on the exact same plinth, then it is possible theoretically to do it in that same location, or within that 1 meter sort of position or location. But in many instances, it's actually not. So having that bit of operational flexibility would allow us to do that installation in a safe manner, with maximum amount of barricades, allowing our guys that flexibility and that safety net to work in that location. Yeah, that's a pity I didn't have any pictures or examples on that slide to show you, because most of the sites that we are referring to in these areas, most of them are ground-mounted assets in these areas.
And it doesn't necessarily mean that you're going to take that whole 6 meters. It could be that it may be just one side of the existing. So it could be 3 meters this way or 3 meters backwards.
Yeah. And I mean, we'll do our best to put it as close as possible, but generally every transformer would have a ring main unit or an 11 kV switch next to it in most instances. And I mean, thereafter we would remove the existing asset and we would make good and re-establish the ground and the turf or grass or whatever's at that site, re-establish the site before we leave.
And if it comes to anything like a pole replacement, so what we do in our GIS system, all these assets are marked. So if in future we need to replace the pole again, we'll put it back in the old hole. So we'll have two areas. It'll be the similar north same to a transformer. We've got a GPS in our GIS system. If we need to say in 40, 50 years time, make another change, we'll just go back to the same place. So we're only really moving in two areas.
Yeah, that's helpful. I just noticed the rule talks about maintenance, repair and upgrading. But I think your evidence really seems to be focused on upgrading, but not so much maybe on reading. I mean, if I'm going to break this rule up a little bit, would 1 metre be okay for maintenance?
It'll be pretty much the same thing because the scope of the job would be pretty much the same. For example, if you had a car versus pole or a car versus, one of the electrical boxes on the side of the road, the scope is going to be the same. It's not going to be too much different.
Yeah, well, I'm assuming if it's like it's a pole, you're maintaining a pole, you're not going to be replacing it. That's upgrading, isn't it? Whereas maintenance means also replacement.
Maintenance is also replacement. I mean, 50% of the works we do are asset replacement, maintenance works.
And repair could mean replacement too?
Repair could be replacement of assets attached to the structure. For example, a fuse base.
Okay, and so when you're talking about upgrading, you're sort of talking about like new technology or a different
Bringing
type.
it up to standard is usually the biggest thing. Is technology changes. Bringing it up to standard.
Yeah.
And I was also thinking there was possibly room to move where you could have certain activities could be 1 metre, but maybe, and then you could have but you can go to 3 metres where this is involved and there's no other practical alternative or something. That might be an option, something to consider. I'm sorry with the council officers. You've read this evidence. If you've got any response that you'd like us to hear at this stage, again, you don't have to tell us how you might look at it or talk about it, but at least it's been out the court.
Now, I think the only comment I would make at this stage is that I think there is a difference between what is practical and completely understand the operational constraints that these guys are under in terms of when they need to do the works and the separation safety, and absolutely acknowledge that those are the constraints that they're under. But this sort of variation was recommended, and I put it in place because it's a step down from a full discretionary activity, which is what was notified. So this was discussing with John in terms of at what point when you move an infrastructure asset are you elevating the risk of impacting the values of that heritage area overlay? How far are you comfortable sort of having something move before there is an increased risk of actually impacting those values? So the design of the rule and the focus of the 1 metre isn't there to provide a permitted activity pathway that meets Top Energy's practical requirements. It's a balanced, compromised recommendation to move away from full discretionary activity status, especially in those Heritage A, those Part A overlays, which is what it was before, towards something that manages, I guess, the worst of the risk, which is when you have an asset that moves quite a way away from where it was before. That's probably about as far as I would go with that.
Yeah, well, you have to hear more from you if you think you could come up with a more nuanced approach. I think we acknowledge the concern, and I'm not saying we're going to make a call either way, but there still seems to be a little bit to resolve, and that we're not disputing the need to do these things. We're not disputing the need for flexibility. The question is, what is the appropriate rule framework? When it affects this.
Yeah. When it is a historical area or heritage, again, this is where our process, we still engage our archaeologists and they will do an assessment. And if it needs to, if we need to go through an authority to modify a process, we will. Or if it's something that can be monitored by them, then we will do it that way. But regardless of where we put it, we will always get their advice on this because of the history, I guess, and the protection of these areas of significance.
If I could maybe make one clarification, is that in terms of this 1 metre variance, it's very much designed to manage above ground effects.
Yes.
The mechanism and the rules to manage below ground effects with respect to archaeology is the 500 metre depth. This is more about, and this is why this particular provision is really only in terms of scheduled heritage resources which are above ground, or in those more sensitive Area A type overlays. So it's a straight permitted activity in your Area Bs. So it's more about the impact of physically moving something and what that does to the heritage values of the surrounding area above.
Thank you. I think that's been quite an interesting and robust discussion. I think we're better informed now. Right, so I think we're pretty close to your...
That's it.
Yes, that is it.
Yep.
Okay, we're very close. Well, thank you very much, all three of you. It's been really helpful. May feel like it's been a bit truncated, but we've read the evidence here quite carefully.
Understand.
And we have a couple of really focused questions. I also want to see if there's any more questions from the panel members.
Yeah, just around the sites of significance and the proposed new objectives and policies that have been put forward. Existing infrastructure, I get, and thank you very much from Tara and the team in regards to protocols and processes that you've internally got established, which is great. Just a bit of a point, I suppose, for me is new infrastructure, development of new infrastructure. Again, you signalled, Taryn, that your processes are in place, apply for new as well, which is why I asked that question previously around collaboration with iwi. I mean, that was the only thing I sort of saw in the new objectives, managing the adverse effects of the development of new infrastructure. So I just wanted to sort of also put a question to the council planner in regards to that new objectives and policies. Because in the policies, there's reference to, sorry, backwards and forwards, and this is on the evidence from Melissa and David, there's reference to functional need and operational need. So this sort of language is coming throughout the district plan because it was there for wetlands and everything as well. So I just wanted to ask the council planner if they had any comments around, in particular, new development of new infrastructure as opposed to existing.
Sorry, just to, is that, this is in relation to SASMs?
Yeah,
Okay.
significant size.
Sorry, that's a good word. Teresa, did you catch that?
No, I didn't.
Sorry, you can repeat that for me.
I think you thought it was directed at me, but yeah.
It's just about the proposed new objectives and new policies on top energy and around the infrastructure, because of course you're making reference, it's in the infrastructure chapter.
Yeah.
So top energy have proposed new objectives and new policies, and in particular, existing makes sense. You know, it's the replacement, renewal, all the maintenance, etc., makes sense, and we've had some good corridor from Taryn and Nishan. So it was more the proposed objective and policies that make reference to the development of new infrastructure.
And the addition rule as well,
Yes.
extended rule. Yes, so as I said in my commentary report, that was being addressed in the infrastructure chapter. So I've just reached out and I looked in the infrastructure chapter at the objective. And I've reached out to the writer of the infrastructure chapter and that discussion and consider it.
What I've replied, I think, will.
That'd be great.
Yeah.
That was a question. Yeah. Thank you. Yeah. Sure. No, I can leave it for that. Thank you.
Okay.
Thank you.
If I might add to that question, David and I very carefully worked through these recommended provisions to you. You'll note that we haven't asked for a permitted activity for new, recognising exactly what you're saying. And this policy is very carefully worded and tiered. I know that it's also in the context of the rest of the sites of significance chapter. So when you have a discretionary activity, you need to read the objectives and policies in the round and assess them in the round. Functional and operational are defined terms. So, and it flows through, and I'm sure you've all heard from David and his past evidence through all of the hearings that there are higher order policy directions with respect to provision of infrastructure and regionally significant infrastructure and electricity provision. So we've tried to reflect those within this policy that we've put forward to you, but also recognising that significant and adverse effects have to be avoided. So we've tried to create a package policy, recognising the sensitivity of the location. Thank you.
Great, thank you. We've got no more further questions for you. Thank you again to all three of you for attending remotely.
Thank you very much.
Thanks, guys.
So, scratch that.
Okay.
So I do have 2 or 3 questions of clarification, Mr. Chair.
Right.
Just in response to some commentary from the top energy staff, actually point of clarification about when they would, just to clarify what I heard, that in advance of works on underground infrastructure, largely in urban settings, they would call an archaeologist in advance. So that's when they would.
Sorry, so urban settings.
So in the urban, you're dealing with underground assets, which I think I heard was largely in an urban setting, and I think we've heard from Top Energy in previous hearings that undergrounding only occurs, largely only wants to occur in those settings, that an archaeologist is consulted in advance of those works.
It would depend on the area where it is. So for Kirikiri, for example, we've had works reviewed by archaeologists and they haven't found anything, but unless you're working down by the stone store, anything like that. But if you're in an area like Russell, of course, that's a zone.
And I think I also heard, again for Top Energy staff, that while they undertake works in heritage area and use the emergency powers under the RMA and I guess works in and around heritage, but they don't appear to rely on that for the trees. So there's a specific rule on trees. So there's no specific, they haven't requested a specific rule for heritage, but they rely on the RMA powers for works around heritage sites when there's an emergency. Is that correct?
So we are bound by the Electricity Act 1992, and so emergency works come under that.
But we do have our accidental protocol.
Yeah, so that's where, like, if the Electricity Act 1992, so emergency works, it's defined that if it is a risk to life, property, or anything similar like that, we can go in and do the repairs or replacements where it needs to be done.
If I may, so I think, are you saying that that specific exemption hasn't been sought in the heritage area or heritage provisions, but has for notable trees?
Correct.
Correct. As Tara says, they rely on the Act.
So the Act wouldn't therefore apply to notable trees. Is that the implication? Because
of the regulations for trees, there's a relationship there. So we felt that it was best to have that clear in the provisions.
And I thought I heard, Mr. Chair, that there was, again, I apologise, that there was arborists on the team that had a level 4 qualification. Did I hear that correctly, or did I mishear that as well?
Yeah, we clarify that. I think you were saying that you had technical skill. I don't know whether you said you had arborists.
So we have a vegetation team in our contracting division, and there are members in they do have a level 4 qualification.
So you have staff with a level 4 agricultural qualification in your team.
Thank you, Mr.
No, thank you. That's good clarification. That's what she said. We're going to be finding out what all these different levels mean tomorrow. I've been Googling it myself, but I want to hear it in evidence. Okay.
Mr. Chair, I've just been informed that John's online now and potentially available. Maybe just
Mr. John Redfern, who's our
the arborist.
Redfern.
John Reed. Okay, he's available on here. Right, okay, well, switch over. We've got another witness coming on board. So, just so, there he is. Hello, Mr. Redfern.
Hi.
So,
can you hear me?
would you like to direct the question to him?
You can ask the question.
Yeah, sorry, it's about level 4. Right. Can you understand the various levels of arboricultural qualifications? In particular, we're wanting to understand what a level 4 arborist is and a level 6 and level 8.
Level 4. Level 4. Difference between level 4 and level 6. Level 4 is a New Zealand certificate that you get in arboriculture. It's designed more for the operationals. You get base training in trees, tree health, and so forth, but it's more the operational side of things. And level 6 is more for the consultant arborists or municipal arborists or urban tree foresters. So they get a bit more of an understanding of tree risk, tree management, and so forth. Level 6 is just a diploma. Level 4 is a certificate, New Zealand certificate.
Right. Is there any higher levels than that, or is that those the two main levels? Is there a 5?
In New Zealand, there's not a higher level than level 6. Overseas, there's a master's, I think you can get in England.
Is there anything less than 4, and is there a 5?
There is a 5. The 5 is like an in-between, sort of between 4 and 6, of course, but you get a bit more understanding of tree contracts. So it's more for the contracting side of things. There are levels below 4, but it just becomes a little bit blurry because it's more of a horticultural certificate than an arboricultural certificate.
Okay, no, I understand that. And I suppose it's in the question of what is the appropriate level of skill to prune a scheduled notable tree?
Well, we have this discussion all the time, and one of the main things is that there's not a huge level 6 around. There's not many people who do it, and you usually wouldn't find a level 6 on the tools, so to speak. So level 4 is appropriate because you get all that training, all that knowledge to undertake that sort of operation. And from a personal point of view, I think it's reasonable to ask someone who cuts notable trees to have that sort of training.
And tell me, is the level 4 certificate quite common? Are there a lot of arborists with that level of training?
Most people are working towards a level 4. So yeah, it is quite common.
Right. So, when you would normally call out an arborist to assist in any tree works, are they likely to be level 4 or?
It's hard to say. I couldn't tell you if it's likely they'll have it. It's quite common through that operational side of things on trucks and pruning around power lines and trees.
What I was trying to understand is there, are there a good number of these people practicing? Is it easy to get a level 4 arborist to do these sorts of things?
From my understanding, what I know of, and that's mainly in the Auckland area, that it's a requirement to have a level 4 on what we call the bucket truck, which is the trimming around the power lines.
Right, okay. Well, that's quite helpful. Anybody else want to ask any further clarification? Any council officers want to ask a question? I might even let the council, the top energy, do you want me to ask him another question? Any questions? You quite happy with those answers?
I'm happy with those answers.
Okay. Well, thank you very much for turning up at a moment's notice. It's actually been really helpful. It's certainly edifying me anyway.
No problem.
Thank you.
Yeah.
Right. Pretty much wrap it all up now. So thank you very much for your presentation. It's been a really good discussion. Thank you. Judges' reports.
Did run for an hour.
Yeah, there you go. I'm conscious that we have Mr. Sanson waiting very patiently.
Thank you very much.
Cheers. Thank you.
Bye.
Okay, Mr. Sanson, how much time do you think you need? Well,
you read it?
the questions I asked you.
Straight into questions.
Yeah. I have to say, we've read your evidence quite thoroughly, and it's it is quite clear. But you know, come and have a seat. And has anything changed since then?
No, nothing's changed. I had a presentation, but I think it's, like you said, reasonably clear. I've just got the hard copy book if you wanted to see it where the site is as well.
But I have one question for you. I think it's just a little typo. Is that in paragraph 15, you refer to NA 45C 958, and I thought you actually meant 46C 958.
Yeah, sorry.
Because I've been careening around trying to find this other title, and then I realised it's not possibly a typo.
Yeah, that's the typo.
Okay, no, that's good. Thank you.
I guess the reason I brought the hard copy was really just to show how they've got the boundary lines on that map and how they used to, I guess how they used to identify sites was quite unspecific, I guess, to how we would want to see it today around a parcel or a defined area as close as possible. So I guess you see the evolution from a circle with a number to then across a site. But I think if you look at Figure 5 together, it clearly talks about a place or a description that's called the Awapoko Reserve. And when we bring down to Figure 6, that also talks about the Awapoko Reserve and the Part Okukuri block. And so, my evidence is that between this 1988 Manganui County scheme and through all of the various drafts and proposed drafts until we got to what we got here is that we've had the incorrect scheduling across Okukuri B.
And so really it's that thin sliver adjoining the coastline which has the resources that your client believes are the site of significance, and that it's just been a sort of like a dot put on the sort of land part, the greater land parcel, but otherwise constrains the use of that land.
Yeah, that's correct.
Yeah, and I think we've heard today that pretty much all the operative plan sites really just got rolled over. So unless that error had not been recognised before it happened, it just got rolled over. Is that a fair summary, Councillor?
Yes. Can you just repeat that last sentence?
Well, I think the majority of the sites of significance in the operative plan were just simply rolled over.
From previous plans.
Yeah, and so this is the first time you sort of said, well, hey, it's not this entire parcel of land, it's just this bit. Is that the first time that's been brought to the attention, Councillor?
This was the first, in my knowledge, it's the first time we've done a site of significance review, and I wouldn't characterise it as that, it's been thrown into the PDP. So this is the first crack we've had at it.
Is Council able to give us any indication as to whether this evidence is correct? It's incorrectly identified, or?
I've read the evidence, and it's the issue of the accuracy of the site has been raised before through a resource consent process. I would like to interrogate it
a bit further.
Sure.
Okay, so you acknowledge the evidence, you acknowledge that it's possible, but you'd like to do some further investigation. While we have Mr. Sanson here, is there any further resources or information you'd like to assist?
No, but the, just to acknowledge that the evidence from the Nottingham Court petition is helpful. Not at first blush, no, I can't think of anything else.
Can I just add though, sir, that with respect, the council have had these submissions since 2022. You know, we are now close to 2025, and there are live issues at play, and that the incorrect scheduling or scheduling off sites plays a role in when people are wanting to do activities, and this is an active case where that scheduling or that and the council process is in my view hindering a resource consent application, which blanket says if you're doing a consent on the site and you're not the requesting party, my evidence in this case is that they are the requesting party, but the tying of the two sites gives an indication that that other owner has a role to play in that consent application. So I just want to just make that clear that it seems like a very long time to then be told to wait some more. So,
okay. I mean, within the scope of the right of reply, is that enough time to get to an appropriate level of interrogation? You think?
I think so.
Yeah, okay. Well, we're talking about weeks now. So I hope that gives you some comfort that this will be addressed. So I suppose your evidence is that this is now a live issue and it's affecting a resource consent application. So I think council officers have heard that. And hopefully we'll have that addressed in the right of reply. Anybody else got a question?
Oh, whakamārama mai kia I pohi e koro ana koe mo te top energy ngari, koro ana koe mo aurere. So, mohe au kei reira etahi āwangawanga I wainguri ngā rōpū e rua. So I'm not sure kowai, o mohe au kowai, engari I don't know who has A or B. Can you just summarise that for me, please? Sorry.
Yeah.
You know, quickly, like, how te tino take e pēnei ana?
okay, so from our view, and it's in the, if you read the Māori Land Court evidence, is that the owners of Whakakori A have a land issue with the owners of Whakakori B. Land issues, though, can't be resolved through the resource consent process. But in my view, they're now using that incorrect scheduling to be constantly limited, notified in a resource consent application for any activities.
So I'm still unsure who's on A and who's on B.
B is Sir Hex Land.
And which one has a resource consent? B or A?
B.
B.
Yeah.
And so do they want A to concur or?
Well, we're the applicant saying that A shouldn't be involved. And they are involved because of the scheduling of the property, because they're tied so closely together on the map. And I think if you look at figure 2, that just shows how it relates all the way up the beach, but then also on the area where the Waka Centre and the activities are proposed. Yeah. So that's the beef.
Will a hui help or not?
There's been 2 to 3 years of trying to hui about this, and this recourse is now sort of in front of us. So, yeah, that's the position we're at the moment.
What's that?
But they would still have rights of appeal. Okay, but that's for another process.
Yeah, sorry, I mean, I'll just jump in. Thank you, Mr. Sanson. I get the map needs to be changed. The schedule, how do you propose that the schedule needs to be changed? in terms of that.
Well, the schedule is correct, isn't it?
Was the schedule correct, but the map is wrong?
Yeah.
Okay. So that's the only thing, the map is the only thing that needs to be changed?
Correct.
Okay. Just move the dot, move the reference on that.
Correct.
Okay, yeah. That's clear in my mind. Thank you.
Just a little bit of clarification from, thank you for the evidence and the cordial that you've given here today. So, Okikori A is where the site of significance should be scheduled, because it's got Waitangi there as well, component. Whereas Okikori B is where the Whare Waka Wainanga location is, and you're seeking that it's not part of the scheduled site of significance. Was there, from what I remember reading, is there an intention that Okikori B is a Māori reservation itself? No?
Yeah, that's,
But not scheduled, not in the district plan schedule.
Yeah.
From a Māori land perspective, it's a Māori reservation specifically for Waitangi Waka.
Yeah.
I just want to clarify.
Yeah.
Seems to me.
B is the waka.
Yes, that's right. And that's Māori reservation process. There was a letter there as well, sorry. Is it this one? No, it's a letter from some. Yeah, there was a letter. No, I'm getting myself mixed up.
There is a letter that starts with Hi Shane.
Yes,
And so,
and Shane is part of the trust.
part of Arawai, yeah. But yeah, this was from a council officer.
Yeah, it didn't have any dates to it, and who it was related to. That's right, that's what I was meant to say.
I can find those.
It's correspondence, wasn't
Yeah,
it?
it's correspondence, yeah.
That was council correspondence.
We're talking about the email that was attached to whoever.
Correct.
Okay. Do you know when that was? It doesn't have a date.
No, I have to find the date for you, sorry.
Thank you. It's a few letters, so. Kia ora, thank you for looking that for me. Yeah, kind regards Mr. Powell, which is the council officer, would that be correct?
Yeah.
Okay. Yes. Thank you.
Thank you, Mr. Sanson. Thank you for patiently waiting. Anything else you want to add? Or that's all you need? Well, thank you very much.
Well, that was helpful, thank you. Yeah.
That brings us to a close for today's proceedings. Thank you very much. Those members have been sitting here all day and listening. Thank you very much, council officers, for your input today. We'll be adjourned until 9 o'clock tomorrow. And starting off with.
Just a little bit sad that, sorry, O'Leary had this minimal time at the end, and I try and understand what's going on. Nina, you must have.
I do.
Yeah.
Conflict of interest.
Conflict of interest.
I'm actually a shareholder.
Right. Oh. Which one, A or B?
Both.
Both. Yeah, I just really want to say for the man of that whole kaupapa, you know, it's, I'm just sad it's at the end and I thought we were in a bit of a hurry. I had read it and I was getting muddled even when I read it. And
That's more than probably my issue.
no, it's not. It's just slow age. End of the day.
I was going to say we've got plenty of time. I mean, I wasn't trying to rush anyway. But you know, I read your evidence. I understood.
Yeah, I couldn't say any more.
Yeah.
On fire.
I think you've said what you wanted to say.
Yeah, there's a
So ROI want to put a whare waka on Okikori B or Okikori A, who are the local other members of the local hapu, object because a process wasn't followed or because something else was issued without them being involved?
Gosh, it was quite a long story, so I'll try and keep it brief, but as long as I've been involved, we've tried to carry out the, do the right consultation. We get so close to a meeting to then being told, oh, no, we can't meet. And so it's this constant stop and starting. The previous consent got declined because it didn't have any cultural impact assessment. It's been relodged with a cultural impact assessment to be now be told that the scheduling of the site gives that party to the Okokori A the right to be instantly an affected party. So it's this constant going round and round where we try to meet, can't meet, go lodge a consent, have all the information to then get to a hearing to hear things over and over again. This process has come up. It's the opportunity to, make right in the submitter's view the incorrect scheduling. And if that's successful, it will. But I don't think I'm here to say that that'll get rid of this current consent right now.
And all I would add is that it wouldn't be an immediate resolution.
No.
We'd literally be waiting till June.
But it is,
unless you're asking for us to make an.
Well, if you're of the mindset.
We would have to be asked. No, I wasn't necessarily going there, but I suppose it's possible. I was going to say, but I mean, obviously, this process, we're hearing the evidence now, but council won't actually make its full decision until June next year. June next year?
May is the extension from the minister.
May. So 11 months. Obviously, that's your client's happy with that time. Accepts. Yeah, so happy, but accepts.
Wasn't there an
there's no other option yet.
Wasn't there an expiry date or something? Wasn't there an expiry date on the whare waka? I'm not sure.
No, no expiry date. I mean, what they've had to do in the interim is carry out works that don't need consent. So because they're general coastal, they can do 25 square metre buildings. So like doing all these workarounds to still establish a tourism centre and try to get people engaged in the opportunity without triggering all these consents.
So you will get more of this tomorrow, this context.
Yes.
In a very similar vein.
Okay. Well, I think we've taken this as far as we need to. Thank you very much again.
Thank you.
Mr. Sanson and officers will be adjourned until 9 o'clock.
Oh, just close us.
Oh,
Karakia.
Is it going to be really good?
Okay, it's going to be.
Okay.
Po hirihiri, po ramarama, po o te whakaaro, po o te tangata, po o te aroha. Ti po I hiri nia ia tātou, mauri ora kia tātou, homie, huie, tātou. I will stop the recording.